No, let's not debate it.
In fact, that's why the explanation to B contains an exhaustive definition of what is meant by the government of the state. Government of the state does not say includes the Maharaja. It says government of the state means the person for the time being recognized by the president as the Maharaja of Jammu and Kashmir,
Correct.
acting on advice of the Council of Ministers for the time being.
Right.
Now, what happens when the Maharaja is replaced by an elected government in Jammu and Kashmir?
Then the elected government on the aid and advice of the Council of Ministers.
Where do we get that? Because the explanation says government of the state means.
Well, I'll show that to your lordship. That's also there, Malad. It is part of the constitution, Malad. I'll show that.
This explanation was introduced in 1952.
Well, there is a government order of 1965 which says that Sadr-e Riyasat will be in the governor.
67?
Yes, 1965 order.
65. So till 65, did the Maharaja continue to
Yes, yes, Malad. Then
There were separate powers of Sadr-e Riyasat.
Yes.
But
Malad, ultimately,
equivalent of chief minister was called the prime minister.
Yes,
for
that's
some
correct.
period of time.
But in
Those
65, Malad,
terminologies
it was the
were,
governor.
removed.
There's an order to that effect. So be that as it may, Malad, I think we're traveling a bit too far at the moment. Now kindly see, Malad, the preamble of the Constitution, your lordships will find volume 2, PDF page 16.
Now we are looking at the J&K Constitution.
That the Constitution of India is applicable under J&K Constitution.
JNK Constitution.
Malad, just kind of page 5, PDF page 5, volume documents, volume 2. Just it's the index, Malad, really. In this constitution, unless the context otherwise requires, the Constitution of India means the Constitution of India as applicable in relation to the state. Then kindly come to Muller's Article 3, the state. Relationship of the state with the Union of India, the state of Jammu and Kashmir is and shall be an integral part of the Union of India. This he can only do it on the aid and advice of the Council of Ministers. It's not an exception because the exceptions are 36, 38 and 92. This is important because it really, the issue will arise because there was no Council of Ministers when he did this, which is on the 21st of November, 2018. The importance of this is that he can only dissolve the Legislative Assembly on the aid and advice of the Council of Ministers. The only exceptions that the governor has in the terms of his exercise of power are 36, 38, and 92, which he need not do on the aid and advice. But under 53, he can't do it without the aid and advice, which is what he did. Well, I'll come to that later. Now, Mullahs, 92, which is that exception. I was mentioning, Mullahs, as far as 53 is concerned, that power to dissolve the assembly would only be exercised on the aid and advice of the Council of Ministers. So when he dissolved the assembly on the 21st of November 2018, he didn't do it on the aid and advice. And this governor's power has to be exercised in that fashion. The only exceptions are 36, 38, and 92. So, Mullahs, the proclamation was issued on November 21st, 2018, on 20th of June. It was to expire in 6 months' time, on 19th December. And Mullahs, on November 21st, he dissolved the assembly. And without reference to the Council of Ministers. But anyway, we'll come to that a little later. Now, most important, well, is in the context of what we've been arguing all of yesterday and today, is 147. So, Mullahs, you cannot amend 370 as it is made applicable to the constitutional order made applicable to the state of Jammu and Kashmir. So no legislature can even move a bill. This is what makes it permanent. This is exactly why it is permanent. It had to be temporary because at that time there was no Constituent Assembly. It was temporary, it had to be temporary, per force it was temporary. Even 3 cannot be amended. Section 3 cannot be amended.
But can the permanency of Article 370 be a consequence which follows from the Constitution of Jammu and Kashmir?
No, it's made applicable to Jammu and Kashmir by an application order.
No, but you're saying that this provision,
Yes.
Article 147 of the J&K Constitution,
Yes.
makes Article 370 permanent. Can the permanency of the Indian
Yes,
Constitution...
because, brothers, kindly see, the 370 was made applicable to the state of Jammu and Kashmir by an application order. 373, brothers, kindly. Subclause 3 gives powers to the Constituent Assembly, no?
Those powers clearly
Those-
doesn't have.
That legislature doesn't have those powers. Ultimately, what happens is when you impose Article 356, you took over the powers of the legislature. Under which power did they exercise that right?
Not of the legislative assembly.
Yes, exactly. That's what I'm saying, brother.
Mr. Sibal, how
But then
can
how
we,
is proviso C will applicable?
Yeah.
how can, you are saying Article 147 gives the permanency to Article 370?
Because the Constituent Assembly, I'm sorry, I shouldn't interrupt you, Lord.
Now, can the Constitution of J&K give a permanency to Article 370 of the Constitution of India?
Exactly.
But that's all we are saying is that the Legislative Assembly does not have the power under 370 subclause 3. That's all that I'm saying, nothing more than that.
What you are saying is legislative assembly cannot exercise the power under the proviso to clause 3
Yes.
of Article
So what,
370.
then
That's not-
why they did, they converted the Legislative Assembly into the Constituent Assembly. That's what they did, Malaj. This is what is shocking.
The lighter side, the Parliament did it.
I'm sorry?
On the lighter side, the Parliament did it.
Yes. So Parliament converted itself into the Constituent Assembly of the state. I mean, it's unheard of. Yes, no means, but we'll show it. We'll show it. We'll demonstrate that. At the moment, all I'm saying is, Millers, you cannot exercise, the legislature cannot exercise powers to amend 373. Yes, even some other body takes over those powers, that only powers can be exercised, is the powers of the legislature, nothing more than that. That's the whole scheme of 356 is if you take over.
The Parliament can do it or not.
Yeah, well, Parliament exercises the powers of the legislature under 356. It can't exercise any other power. And that's the scheme of 356, which I'll come to later. That's Bomai, mothers. Now that's settled. You can't arrogate to yourself a power that the legislature doesn't have. That's why there's an interplay between the Constitution of India, the Constitution orders applicable to the state of Jammu and Kashmir, and the Constitution of Jammu and Kashmir and 370 itself.
That's what you flagged in the beginning when you began your speech.
That's the issue.
Actually, Article 147, the second proviso to Section 147 of the J&K Constitution, would seem to indicate that the provisions of the J&K Constitution are treated to be subordinate to the Indian Constitution, which is why no amendment in the relationship of the Indian Constitution and its application to the state can be introduced in the state legislature. The state legislature cannot change that relationship.
Correct, but I'm not disputing that. It is the legislature cannot introduce a bill to that effect. And what's the procedure? Only under 370. It's only under 370. Man.
But this is in that sense a subordinate instrument in its application to the its relationship to the Constitution of India.
But let's kindly see, 1 second, kindly see, just 1 minute. Kindly see the Constituent Assembly has now framed the Constitution. The Constituent Assembly has not exercised the power that it had, Malaz, to abrogate 370. In that process, the Constituent Assembly, when drafting the Constitution, decided that nobody can change that status. The legislature cannot change that status. Now, whether Parliament on its own can change that status is a separate issue, but the legislature cannot change that status. That's the element of permanency as far as the legislature is concerned. Let me put it that way.
The legislature has no authority to change the relationship between.
That's correct.
That's what you're
Legislature
saying.
change. Why? Because this is not a temporary provision. That's clear, Manoj. The Legislative Assembly also can't touch the provisions that the state of Jammu and Kashmir and shall be an integral part of India. Section 3. It also can't touch extent of executive and legislative power of the state. Can't touch that. And it can't touch 370. So from the point of view of the Constituent Assembly, when the legislation was drafted and the Constitution was drafted, it was clear that this relationship is permanent.
Just one question. The proviso to Article 147 of the J&K Constitution says that no bill or amendment seeking to make change in the provisions of the Constitution of India is applicable
Yes.
in relation to a state
Yes.
means a change in the Constitution of India. Whereas, as per clause 3 of Article 370, it's not the amendment which is applicable. As per that, it's the consent or the consultation or the
Recommendation. Neither consent nor consent. It's a recommendation.
no.
Of the legislature.
Let's see
Of the Constituent
373.
Assembly.
Let's see 373 for
Yes,
a minute.
please.
So really speaking, under 147 may have no application as far as, because you're not seeking to amend 370, but enforce 370. Let's assume, for the time being, substitute the words Constituent Assembly for Legislative Assembly. On the recommendation,
Yeah.
let's assume so.
Yeah.
Let's substitute. You're right,
Correct.
recommendation.
Correct.
Let's substitute that word, provided that the recommendation of the Legislative Assembly for the state referred to shall be necessary before the President issues such notification.
Yeah.
So really, 147 will not be applicable in case the state legislature makes that recommendation.
No, but let's kindly see what 147 says is the provisions of the Constitution
But
of India
you're not
as
amending
applicable in the relation to the state.
You're not amending the Constitution. You're not amending this Constitution of India. For the time being, let's read as it is, because what is barred under the proviso to 147 is amendment seeking to make a change in the provisions of the Constitution of India.
As applicable in relation to the
As applicable in relation to the
which is
state.
why 370 is incorporated, Malad, in the Constitution of Jammu and Kashmir. As it stood then, that's the application order. We're not talking about the Constitution of India here.
Sibal, doesn't it, I'm just thinking aloud.
Yes.
Does it not mean that the proviso, the implication is that once the provisions of the Constitution of India are made applicable by different orders,
Yes.
you through an amendment cannot
That's all
deactivate
that
it.
we are saying. Nothing more.
And deactivate a provision which has already been applied to
Yes,
the Constitution
that's all that we are saying.
of
Nothing more than that. We're not amending the Constitution of India. We're amending the constitutional order applicable to the state of Jammu and Kashmir, which makes 370 applicable. And it can't even be moved in the House. And if it can't be moved in the House, it can't even move the bill. It can't be moved in Parliament.
As I see it, it's that you can't go back. Suppose after consultation, the CO has been issued, order has been issued, notification has been issued, certain provisions of the Constitution have been made applicable.
Yes.
Then it's not that a rethink can arise 10 years later and you start
That's all.
and say that, look, okay, we don't want to make some of the Constitution provisions
Absolutely.
already made applicable,
Correct.
not applicable.
So my argument is that the Constituent Assembly has exercised its choice. And it's evident from the provisions of the Constitution itself. So you need to read the Constitution of India, the orders applicable to Jammu Kashmir, the Constitution of Jammu and Kashmir, and 370. So under what provision of law under the Constitution of India can you change that? When you are doing it under 370, 356.